track 2 of the afternoon session. Some of you might be joining for the first time, so welcome. And for those of you who joined this morning, welcome back. My name is Patricia Kubala. I am a PhD candidate in the Sociocultural Anthropology program at UC Berkeley. And it's my pleasure today to moderate this, what was originally intended as a breakout session conversation around the theme of should groups petition the DEA for a religious exemption for psychedelics? So that is the question under consideration for this breakout session. And we are going to attempt to make this as interactive as possible, and we're considering our circumstances. So for those of you who have not, we're just now joining Crowdcast, there should be on the right side of your screen the chat stream, and you are welcome as you are participating as a listener in this conversation to write some thoughts, questions in the chat stream. There's also the Ask a Question box at the bottom of your screen. And there you can post some questions and vote on questions that others have posed. And in the second half of our conversation today, we'll be choosing some of those questions to answer. So before we get to that, though, I wanted to spend a few minutes introducing a little bit more the theme of the conversation today, and then also introduce our speakers, who are Jack Silver, Robert Heffernan, and Jesse Hamilton Hudson. But I wanted to share first a little bit about the premise of this conversation, as our speakers have described it for us in the schedule. And they write, again, around this question: should groups petition the DEA for a religious exemption for psychedelics? The use of ayahuasca and other psychedelic medicines have expanded quite a lot in the US since the Supreme Court's favorable ruling in the UDV's case in 2006 and the Santo Daime Case in Oregon, Ninth Circuit, in 2009. After these rulings, the DEA created a petition process for receiving a religious exemption based on the Religious Freedom Restoration Act. So the question is, should medicine-using groups consider engaging in this petition process? So here to debate, discuss, reflect on this question with us are Jack Silver, who is an attorney with the majority of his practice environmental. In addition to his environmental work, he also helps guides and facilitators limit their potential personal and criminal liability. Jack was co-counsel in the successful Santo Daime case against the DEA, Church of the Holy Light of the Queen versus Mukasey. He co-founded the California River Watch and is still counsel to its board. And he also sits on the boards of the Green Earth Foundation and Institute for Holotropics. He is a certified holotropic breath worker, a Mota Sinkana licensed tea instructor, apologize for the mispronunciation there, and holds the rank of Sandan in Aikido. He's also a member of Chacruna's Council for the Protection of Sacred Plants. That's Jack Silver. Second guest with us is Jesse Hamilton Hudson. He's an attorney in the US, practicing in blockchain and psychedelics. He was born and raised in Hong Kong and lives in Chicago. He earned his JD with an MS in International Development from Tulane University in New Orleans, and his BA in Anthropology from the University of Colorado Boulder. He is a research associate at the Interdisciplinary Group for Psychoactive Studies, Brazil, USA, and also a member of Chacruna's Council for the Protection of Sacred Plants. And we also have with us Rob Heffernan, who is an independent researcher and activist who has been involved in the Vegetalismo, Santo Daime, and other syncretic traditions since 2000. He has been involved with legal issues and organizing efforts in the Santo Daime and ayahuasca community for the last 12 years. He is part of Chacruna's Council for the Protection of Sacred Plants also, and he is involved with integration work as a certified shamanic breathwork facilitator and a certified integrative sound and music practitioner. This is complemented by long-term involvement also with Buddhist Dharma, and he's recently begun to speak and write about the integration of Buddhist Dharma and medicine work. So welcome to all of you. Welcome to those of you who are listening, participating with us in that way today. So again, to the audience, if you have questions, comments, please share in the chat stream or in the Ask a Question box. And I'll now invite Jack to share some thoughts on this question, again, around our theme, should groups petition the DEA for a religious exemption for psychedelics? Jack.
All right. Welcome, everybody. Hopefully you can hear me. I'm going to start off with a bit of a disclaimer. I'm giving you my opinion, although it's legal in nature. I'm not seeking to provide legal advice or to establish an attorney-client relationship. So getting that out of the way. By way of introduction, I was one of the attorneys in the Santo Daime Case, which is Church of the Holy Light of the Queen versus McCaskey. The reference to that is 615 F Sup 2D 210 or 1210, in case anybody's taking notes. And if you're not, I'll give you notes of my talk. It's fine with me. Also, that case was later the same case, Church of the Holy Light of the Queen versus Holder, because the cases are always against the Attorney General. And so between the time that we started the case and the time that it was appealed, the administration had changed. I'm going to talk, in the beginning, I want to give you an introduction to the Religious Freedom and Restoration Act, which I'll refer to as RFRA after this. That can be found at 42 USC section 2000 small b et al. Talk about its history, its application, and I'm also going to give you my opinion about filing a petition with the DEA for religious exemptions to the use of a sacrament that contains what the DEA claims to be within its jurisdiction to regulate under the Controlled Substances Act, which I'll refer to as the CSA from here in. And that can be found at 21 USC section 801. That's the beginning of the act. In my opinion, filing a petition with the DEA for religious exemption from the CSA is counterproductive to the goals most of us have for the religious use of entheogens, and I'll tell you why. And also, when I use the word religion or religious, that includes any spiritual or shamanic practices. Okay, within the concept of the separation of church and state, neither the DEA or any agency of the U.S. government has a legal authority to determine if a person has a genuine religious belief or practice. Yet, this is exactly what the DEA is proposing. And for those that apply for an exemption, they may be waiving certain constitutional rights that are guaranteed to them and also setting a bad precedence. The First Amendment to the Constitution states, quote, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, end of quote. However, we know that the right is not absolute. For instance, the religious practice of human sacrifice can be completely prohibited. Prior to the Smith decision, which I'll discuss a little bit later, the Supreme Court used strict scrutiny to determine the constitutionality of any law that adversely affected free exercise. In a case called Sherbert versus Werner, which is a 374 U.S. 398, is a 1969 case, the court held out a two-part requirement for state and federal governments to have a compelling interest. And a compelling interest would be things like health and safety in order to restrict religious practice. And even if they had a compelling interest, they could only do that by the least restrictive means. Now, the compelling interest and least restrictive means are what we call terms of art. And they have very, very specific meanings. In 1990, a divided Supreme Court abandoned the compelling interest least restrictive means test that it had used for the free exercise cases since 1993. In the case Employment Division of Human Resources of Oregon versus Smith, and this is what people refer to as the Smith case, which is 494 U.S. 872, The court changed the religious freedom exercise dramatically by ruling that generally applicable laws not targeting specific religions do not violate free exercise in the First Amendment. And this is so-called the neutrality standard. Now, right afterwards, through a bipartisan group of religious conservatives and progressive civil rights representatives, the Congress quickly passed the Religious Freedom and Restoration Act in 1993, just very soon after the Smith decision came out. And that can be found at 42 U.S.C. Section 2000, small b. And that mandated that the court use strict scrutiny in free exercise cases. And it later reversed the court's decision in Smith and restored the compelling interest case that was in Sherbert and Berner. Now, 4 years later, and this is important, that in the Flores case, which is 521 U.S. 507, the court ruled that RFRA was unconstitutional as applied to the states because it violated in other words, Congress violated the separation of powers, and that's a separation of powers between federal and state government. So at this point, I want to note two things for you. The good news is that assuming you're using an entheogen, and it's part of a genuine part of your religious practice, you already have the right to use the entheogen under RFRA, and that right can only be attenuated by a compelling interest and only limited by a least restrictive means. The bad news is that if your state does not have a RFRA statute, like California, where I live, then the neutrality standard applies instead of strict scrutiny. So the CSA controls, quote, legal importation, manufacturing, distribution, and possession, and improper use of controlled substances that have a substantial and detrimental effect on the health and general welfare of the American people, end of quote. However, just because a living organism, for instance, a plant, a fungi, or an animal, contains a controlled substance, that organism does not per se fall under the CSA. An agency must have jurisdiction to act. Whether the DEA has jurisdiction to regulate a traditional sacrament that contains a controlled substance just depends on whether, quote, its illegal importation, manufacturing, distribution, and possession and improper use, end of quote, would have, quote, a substantial and detrimental effect on the health and general welfare of the American public. So despite this very clear avenue to attack the CSA, when litigating your rights, challenging the CSA, that is what we consider a losing strategy, which I'll discuss in a bit. Now, as the Ninth Circuit observed in our case, in the Daime case, the CSA regulations, quote, were explicitly never challenged or litigated, which is true, end of quote. Instead of navigating, and the reason why was that because instead of navigating the regulatory maze, including trying to argue congressional intent, et cetera, we focused on the protections afforded under under RFRA, since the actions of the government significantly burdened the Daime's religious freedom. This is an easier case to make since once a plaintiff has satisfied the burden of showing that they have a genuine religious belief, the burden then shifts to the government, and they must then prove a compelling interest and by the least restrictive means. And at that point, there's no talk about the CSA at all. So in our case, the DEA could not even make its burden of showing a compelling interest. Now, this is where theory and reality sort of meet in the courtroom. And I'll let you in on a little but very well-known fact. Judges do not always follow the law. And then, so in our case, since the DEA could not prove a compelling interest, Judge Panner, that was our judge, should have just stopped there, but he didn't. Instead, he went on to hold that an outright ban was not the least restrictive means, which actually was a great holding for him for us and for the law in general. And although there was no compelling interest, he then fashioned an entire conditional judgment and designed a set of restrictions on the application of the CSA to the Daime. So that portion of the decision was appealed by the DEA to the Ninth Circuit. And the Ninth Circuit specifically vacated and remanded that judgment, holding that it was overly broad and reached beyond the scope of the issues actually litigated. Meaning, we never actually talked about the CSA. We only talked about RCRA. And so there was no basis for the judge to determine that the CSA was inapplicable if it never had been litigated on the merits. Anyway, and since we did not litigate the application of the CSA, the Ninth Circuit essentially had no basis for holding Judge Penner's order. Now, the ironic part about that is that Judge Penner then issued the broadest injunction he could have issued because it was completely unconditional. In other words, he just completely stopped any action by the government to interfere with anything that the Daime did, which was, again, great for us. Now, the question is, one of the questions is can a suit challenge the CSA, or can you have a court declare that a group's practices are exempt? Would that be successful? I don't believe so. And moreover, I believe that litigating that issue may create bad law. And we have a saying that bad cases make bad law. The plaintiff in such a case would have to show that the mere existence of the CSA poses an, quote, unreasonable and substantial burden, unquote. That's the requirement in and of itself. Now, there have been other cases out there that people have quoted to say that you don't need to have someone arrested, or they don't have to DEA doesn't have to take a provocative act. And the one case that they quote is Hobby Lobby, Burwell versus Hobby Lobby, which is 573 US 682. Now, in that case, the Hobby Lobby challenged the Affordable Care Act's mandate to provide contraceptives to its female employees, and they used RFRA for that. Now, a divided Supreme Court, which it was or is the conservative Catholic majority there, ruled that a closely held for-profit corporation to be exempt from regulations that its owners religiously objected to. And if there's a relief restrictive means of furthering the law's interest, according to the provisions of RCRA, and actually there was. In other words, the government was willing to provide contraceptives to these employees so that the employer didn't have to. So that was the least restrictive. Now, this brings us to another reality check. And a quote I like from Dickens, which is, quote, sometimes the law is an ass, unquote. And like it or not, politics, prejudice, and hidden agendas affect judicial decisions. For example, this same Supreme Court in the United States versus Lopez, which is 514 US 549 in 1995, in another 5-4 decision, ruled that the Gun-Free School Zones Act of 1990 had exceeded its authority under the Commerce Clause, despite clear and convincing evidence that these guns were bought and sold, i.e. they were in the stream of commerce. 10 years later, in another case called Gonzalez versus Reich, the U.S. Supreme Court ruled that the federal government had the power to seize and destroy medical marijuana being grown domestically solely for personal and medical uses for seriously ill patients as a valid exercise of the government's Commerce Clause, despite the fact that no commerce, in other words, none of this, there's no commerce involved at all. So this tells you that there is a hidden agenda, and that unfortunately the court follows it. Just think of the all the conservatives on the court. So I make these points because one thing is that we're discussing the law, but the law is never settled. Okay, if it were self-executing, then there would be no need for lawyers or for judges. So over and above politics, prejudice, and hidden agendas, the difference here between the Affordable Care Act and the requirements, the Affordable Care Act that mandates employers provide contraceptives, the CSA is essentially a regulatory statute. And with regard to the use of a controlled substances, it's prohibitive, not affirmative. In other words, it's not requiring that you do something, it's requiring that you don't do something. And that's actually important when it comes to regulatory law. So to prevail, a plaintiff would have to first, this is important. So to prevail, first of all, you'd have to concede the DEA has jurisdiction, which we don't agree with. Second, that the CSA applies to a sacrament, which we don't agree with. Okay, then you have to show that you're unable to comply with the CSA. And finally, you have to convince a court that the law somehow reasonably and substantially just in itself, affects your free exercise. So it's just so much easier to attack government conduct rather than litigate whether or not a certain statute or set of regulations in and of themselves affect free exercise. So, so in the Daime case, what we did is we waited until the government arrested Jonathan Goldman and confiscated the tea and affirmatively prohibited its importation. That was clearly an unequivocal, unreasonable, and substantial burden, such that we had no reason to argue the applicability of the CSA and could focus directly on conduct itself. As mentioned before, if you apply for an exemption to the CSA, you might be waiving your rights under the First Amendment. You are agreeing that the DEA has regulatory authority over the religious use of entheogens, which again, I don't believe they do. And you are agreeing that your current religious use of entheogen violates the CSA, which we argue it doesn't. When we were doing the Daime case, the DEA wanted to determine not only if the Santo Daime was a legitimate religion, but they wanted a list of every member and to have the right to personally determine each member's individual beliefs. So if you were going through that process of applying, you are probably waiving not only your rights, but you may be waiving the privacy rights of your members as well. Now, the fact is that the DEA has never granted an exemption for the use of an entheogen. It is unlikely to do so in the near future. It was Congress that granted the Native American Church an exemption to use peyote, and the UDV entered into a settlement agreement with the DEA, but was not granted an exemption per se. The DEA offered the same agreement to the Daime Church, which we rejected. We have a court order, which is much broader. And what we do now, currently, if we open up a new church, we just send them a courtesy letter and that's it. And we never hear from them. Okay. So another reason to avoid the DEA administrative process is that courts give deference to an agency's interpretation of its own regulations. That's so-called Chevron deference, which comes from a case called Chevron versus NRDC. It's a 1984 case. Now, this actually goes further. In real practice, courts defer to agencies just to their opinions and to the decisions, whether or not they're officially regulations or not. For instance, in our case, look at Judge Panner's reliance on a letter from the Oregon Pharmacy Board. Just a letter. He gave a lot of weight to that, and it had no necessarily legal standing from the sense of a regulatory basis. Now, some permitting statutes and regulations require permitting agents to act within a certain period of time. For instance, once you apply, they have to respond within 180 days, something like that. Now, those requirements are specifically enforceable. However, under the CSA, there is no such requirement in the interim regulations promulgated by the DEA. Under 21 CFR section 1307.3, the DEA has complete discretion whether or not to grant an exemption. And there appears to be no enabling section requiring the DEA to take action with any period of time. Now, suing the DEA for not processing your application entangles you into the administrative process where the odds strongly favor the agency and disadvantage your organization and its members. You are much better off waiting until the government entity takes affirmative action, as occurred in the Daime and the UDV cases. The majority of cases hold that threats alone and your fears are insufficient to trigger constitutional protections. If RFRA applies and you can show a genuine religious practice, the government needs to prove compelling interest. Even if it can show a compelling interest, it can only restrict through the least restrictive means, and an outright ban has been determined not to be the least restrictive means. Now, from a practical point of view, you are more likely to convince a judge than the DEA, your organization and its members have a genuine religious practice. Also, should you win, the court would retain jurisdiction to enforce the consent order rather than you being subject to changing administrations, meaning that, again, here comes Obama, everything's okay. Then comes Trump, everything's screwed again. So that kind of stuff. And who knows what's going to happen in the next administration. So
Jack,
now, just as a reminder.
Jack, I want to invite you. Hi, Jack. It's Patricia, the moderator. I want to invite you to conclude your remarks in the next minute or so.
Okay, I've got just one more debt. So just as a reminder, if you live in a non-RFRA state, getting an exemption from the DEA would not necessarily save you from prosecution under the state laws. And as a practical matter, unless you're big enough, like the Santo Daime or the UDB, it is likely you have more to fear from local law enforcement than the DEA. So whether or not your state has a RFRA-like statute really matters. If there is no RFRA-like statute, then the neutrality standard applies. In other words, the Smith decision.
Jack, thank you so much for that. And we'll return to what you raised in the Q&A and dialogue part of our time together today. So, Jesse, are you ready? Okay.
When I look at your work and think about the precedent that you helped set in successfully defending Santo Daime in the federal courts, years before I even passed the bar and became a lawyer, I can't help but wonder, what am I doing here? Who am I? Why am I here? Where are we going? And if the government doesn't have the right to require churches to file petitions for using psychedelics under RFRA, then why the hell am I going to talk about a church's petition right now? If the CSA doesn't even apply to the sacrament, or if applying for an exemption is waiving your rights under the First Amendment. Like most difficult questions, this one is perhaps best answered with an origin story. About a month before Christmas in 2015, I had a celebrity moment that changed my life. In the comment section of an article about ayahuasca in the Financial Times, I met someone whose work, as an anthropology nerd, I'd read and cited extensively in my undergraduate thesis. That person was Bia Labachi. So I want to say thank you, Bia, if you're watching. And I'm glad I wrote that article you asked me to write. In fact, that article, titled "Don't Believe the Hype About the Legal Ayahuasca Church" going around Facebook, it's not legal, it's dangerous, and here's why, which you can find on Bia's blog, featured the same character about whom I have the honor of speaking on a panel with Jack Silver and my colleague Rob Heffernan at the Council for Protection of Sacred Plants. Ayahuasca healings. And before I get started on ayahuasca healings and what may be, in light of what Jack said, an exercise in futility in looking at their petition, don't get me wrong, I'm a member of the faithful, and I am a true believer. In fact, an example is this Easter Sunday, April 12th, one of my best friends, Johnny, he texted me and said, "Hey, Brad, my boss messaged us and said, Happy Easter, Passover, ayahuasca." And I loved it so much, I'm passing it on to you. And I love that so much, I'm passing it on to you too. As the head of a new ayahuasca church said to me over Zoom the other day, anyone who takes ayahuasca today has to engage in this new religious practice. It's inescapable. Think about that. The ceremonies, the songs, the spirituality, it's all there, albeit in a postmodern syncretic way, as anyone who drinks ayahuasca may tell you. It's there. And it's one thing to talk about, but it's a whole nother thing to actually put it on paper. So what does it look like when someone tries to prove their ayahuasca religion on paper, in writing? It turns out we have an example. And you can find the full text of this example on Bia Labachi's website, bialabachi.net/texts. And you'll find my analysis of it in a forthcoming article on Chacruna. So on April 4th, 2016, in what may or may not have been a move catalyzed by that article that Bia asked me to write, Ayahuasca Healings filed its petition for an exemption for controlled substances from the Controlled Substances Act pursuant to RFRA, which was about 17 pages long. And in that petition, they had to make their case that their use of ayahuasca was A, sincere, B, a religious practice, and C, substantially burdened by the enforcement of the Controlled Substances Act. And if they proved those things, they had a sincere religion, substantially burdened by the Controlled Substances Act, theoretically, they were exempt from prosecution. That said, those core requirements aside, the DEA's petition guidance, which they issued in 2009 after the Santo Daime case, which may or may not have been lawmaking by an agency that is unconstitutional, is a little more onerous than that. And the DEA requires petitions to include detailed information about the nature of the religion, each specific religious practice that involves the manufacture, distribution, dispensation, importation, exportation, use, or possession of the controlled substance, the specific controlled substance that the party wishes to use, and the amounts, conditions, and locations of its anticipated manufacture, distribution, dispensing, importation, exportation, use, or possession. Phew. And it's to be determined in a lawsuit whether that is way too burdensome, and a lawsuit was recently filed. Luckily, we won't be looking at all of that at all. We're just going to look at how they proved they were a sincere religion. First, they tried to prove they were a religion, and then they tried to prove they were sincere. In proving a religion, according to the US government and various precedent, you have three elements. One, you have to have answers to fundamental and ultimate questions that address a reality beyond the physical world. Got it? Answers to fundamental and ultimate questions. Two, you have to have a comprehensive moral and ethical system. And three, you should have structural characteristics of religions in general. So what did Ayahuasca Healings do? Number one, for answers to fundamental and ultimate questions, they described their belief in a reality that transcends the physical world, this transcendent spirit world that ayahuasca showed them. And they also talked about their belief in a transcendent great spirit, similar to a theistic supreme being like God, Hashem, or Allah. The understanding of the purpose of human life as serving something greater, the great spirit or Mother Earth, collective humanity. They described a belief in reincarnation and a philosophy of piety through environmental stewardship. Ayahuasca Healings wrote, "I have walked this path for countless years, or really countless lifetimes. And this is all about one thing, our global awakening." For element 2, comprehensive moral and ethical system, Ayahuasca Healings presented its philosophy of environmental stewardship. It imposed moral duties on its congregants to act in accordance with the spiritual and ecological needs of the environment, and to act in accordance. This church is called Ayahuasca Healings, and it was based in LB, Washington, and to act in accordance with the spiritual and physical needs of other persons. Ayahuasca Healings likened the consequences of breaching these duties to the Hindu principle of karma. Any action one takes against another is simultaneously an action against oneself. It cited Matthew 7:12, "Do unto others as you would have them do unto you." And it described how it had adapted a code of ethics from a controversial church called the Oklevueha Native American Church, started by a non-Native American, which received a lot of criticism for that, and justifiably so, in my opinion, and required various behavioral prescriptions and pledges, such as, "I commit myself to spending every day in meditation and prayer, and I will never share sacraments or sell medicines to those who are not members." For the third element, structural characteristics of religions in general, Ayahuasca Healings described its formal ceremonies, its belief in supernatural entities, diet and fasting, specific gathering places, clergy, prophets, and organizational structure. Organizational structure, an executive body with 3 members. The visionary director, Trinity de Guzman, an online marketer from Canada. A chief medicine man, Mark Kumbuja Banyantri Shakman. And an unnamed third director. Mystery, who knows? Their gathering place was a sacred teepee on a piece of land in LB, Washington. Their formal ceremonies and rituals included purging or cleansing through the use of emetic and purgative plants, the ritualized consumption of ayahuasca, which Ayahuasca Healings likened to Catholic communion. You go up and you stand in front of the priest, and they give you the cup, and you drink the cup, and bless you. And recognized clergy were medicine men and women who have undergone long and extensive training with curanderos in the Amazon jungles. Dietary prescriptions, which were described in detail, included the traditional Peruvian ayahuasca diet. And their supernatural entities, characteristic of religions in general, were not only Mother Ayahuasca and Father San Pedro and the Great Spirit, but also thousands of angels, the ascended masters, Buddha, Jesus, and myriad plant, animal, and mountain spirits. So with those 3 elements, having proven they had a legitimate religion that existed, they went on to prove that they were sincere. And in order to measure sincerity, the government looks at 5 indicators of insincerity. Indicator 1, ad hoc beliefs. 2, lack of ceremony or ritual. 3, the quantity of controlled substance used. 4, the use of other controlled substances. And 5, evidence of commerce. In its petition, Ayahuasca Healings admitted it used another controlled substance, the extract of San Pedro, Trichoceros peruvianus, which contains mescaline. But it stated that it was not currently seeking an exemption for San Pedro, though it planned to do so at a later date. And that San Pedro, while important, was not absolutely essential to the practice of their religion, like ayahuasca. Addressing evidence of commerce in its use of Facebook advertisements and what amounted to a pay-to-pray business model, Ayahuasca Healings admitted it went overboard and actually made a concession to the DEA and said, if you would like to review our ads before we put them out in the future, we're happy to give you that concession. Third, it said that its beliefs were not ad hoc, but derived from shamanic, animist religions of the Amazon rainforest and elements of other belief systems, most prominently that of Christianity. And that it frequently held ceremonies, and so it wasn't lacking in that department. Of those indicators of insincerity, perhaps the one that is most fatal, or would be potentially most fatal to their petition, because it hasn't been replied to by the DEA, and Ayahuasca Healings is now pretty much defunct, and so probably won't receive a response. My opinion is that the evidence of commerce is perhaps the most fatal. And I see somebody in the chat said it's hilarious that commerce is inherently insincere, even to our courts. And I tend to agree with that to a point. I think that there's room for the money changers in the temple, whatever Jesus may think, and that was a big part of the Bible, is that it's not allowed. But I think that there may be room for-profit religious organizations in the future, and Hobby Lobby may be a case that supports that. But that is not legal advice. I am not your attorney, and that does not create an attorney-client relationship. So finally, after proving that they had a sincere religion, Ayahuasca Healings had to show that they were burdened by the DEA, burdened by the government's enforcement, burdened by the Controlled Substances Act, which was pretty easy. Ayahuasca is the sine qua non of their religion. And they wrote, prohibiting petitioners from using ayahuasca would render their traditions useless and devoid of meaning, other than as an empty relic, like an oyster shell with no meat and no pearl. QED. Or, as we like to say in law school, res ipsa loquitur. The thing speaks for itself. So whether or not the DA's guidance is binding, and whether or not the CSA applies to sacraments, and whether or not the RFRA petition survives, any psychedelic church would do well to go through this exercise of articulation, putting things on paper and forming ideas around whether they're a real religion. Are their practices really sincere? Are there indicators of insincerity? And the reason for doing so is twofold. One, you create a manifestation of your own reality, very powerful tool. Two, you prepare your defense in the event that you're challenged. And did I say twofold? If not, three is you may have some fun doing it. Another source that you can look at, DEA, CSA, RFRA petition aside, is actually from the IRS, which are perhaps a more practical agency than the DEA. And the IRS has a list of factors for all churches that they require churches to basically show if they want to be tax exempt, for-profit religious organizations aside. And here are the IRS church factors, which you can find on their website. They are distinct legal existence, recognized creed and form of worship, definite and distinct ecclesiastical government, a formal code of doctrine and discipline, distinct religious history, membership not associated with any other church or denomination, so that your members are your members of your church alone, organization of ordained ministers, shamanic certification perhaps, ordained ministers selected after completing prescribed courses of study, a dieta perhaps, its own literature, established places of worship, like the teepee in Elby, Washington, regular congregations, regular religious services, Sunday schools for the religious instruction of the young, and schools for the preparation of its members. So, who's up for Sunday school?
Jesse, would you like to share further remarks are you feeling complete for now?
No, that's really all I had to say. That's all I had to say, and I'll pass it to my esteemed colleague. Thanks for listening.
Thanks so much, Jesse. And Rob.
Okay, good. Hi, everyone. Well, let me begin by acknowledging that what I'm saying is not legal advice. I'm not a lawyer, and even if I was, being on a panel wouldn't constitute a lawyer-client relationship. I'm fairly well-informed, yet also very fallible. I hope what I have to say is insightful and thought-provoking. In my section, I'm going to explore the question, what special challenges might churches that use multiple sacred plant medicines or synthetic substances have in obtaining an exemption to the Controlled Substance Act under the Religious Freedom Restoration Act, which from now on I'll simply refer to as RFRA. Though first I want to offer a comment on a different matter which we posed in the description of this panel, which is, should various congregations form an association to get together and directly negotiate with the DEA or Department of Justice? That is one of the questions that Chacruna's Council for the Protection of Sacred Plants is just beginning to actively explore with a number of well-organized churches, a team of lawyers, a DEA consultant, and religious scholars. In the future, we hope to have more to say about it. Hopefully, it'll turn out to be a fruitful avenue. It'd be wonderful to have a cooperative relationship with the DEA and Department of Justice, one which would be clear, streamlined, and have very little cost associated with it. We can't say at the present time whether in fact it will turn out to be viable. And given a lawsuit that SoulQuest just filed in federal court 2 days ago, anything we say about the RFRA exemption process here could change, not fundamentally concerning the law, but in regards to administrative processes and perhaps in court precedents. By the way, I'll be basically using the term sacred medicine or sacred plant medicine. Occasionally, I might say sacramental medicine. Some argue to use the term entheogen or sacrament or some other term. Medicine happens to be my preference. And the terms religious, spiritual, and shamanic are interchangeable for me in the context we're talking about here. And the word church basically means a spiritual congregation of some sort. So on to the question of churches that use multiple sacred plant medicines. I'll begin by saying I believe there is a path for such groups. People certainly have responsible and bona fide religious practices that employ more than one sacred plant medicine. And this has been historically true. The Mazatec people of the Sierra Madre Mountains of southern Mexico have used psilocybin, morning glory seeds, and salvia divinorum in their religious and healing practices for centuries, perhaps millennia. There's many other traditions that hold a number of plants to be sacred and essential to their religious rituals, be it tobacco, palo santo, sage, cedar, or the variety of plants used in Amazonian dietas. Those, of course, are not considered controlled substances, yet it is an indication of how multiple plants are used in a religious context. Yet there's also the phenomenological fact known to religious users of multiple substances, which is that they have different qualities which speak to different spiritual needs within an individual or among individuals in a group. Many of us know from experience the different insights, somatic states, visionary states, and spiritual understandings that arise when we take ayahuasca versus wachuma, or psilocybin versus morning glory seeds, etc. They're related, yet they're also very different. Now you may feel, why do I even need to try to explain this to the government? Well, because Congress creates laws like the Controlled Substance Act and the Religious Freedom Restoration Act. The court interprets the constitutionality and application of those laws, and various government agencies regulate and enforce them. That's why at some point we may be called to explain ourselves. It's also why we need to elect the right people to office and demand that they make sensible decisions regarding laws and judicial appointments. In any case, we may be called upon to explain our use if we want explicit protection or if we need to defend ourselves. And let's remember that to mount a RFRA defense, one of the things you need to establish is why the practice that is considered illegal in the first place is absolutely essential to the practice of your religion. Now, in the case of the Santo Daime, the UDV, or the Native American Church, they were only using one sacred medicine that's considered to be a controlled substance by the government. And if you took away that medicine, there would be no religion. You can't have the Santo Daime without the Daime. You can't have the UDV without ayahuasca. You can't have the Native American Church without peyote. So the argument for groups that use multiple medicines would have to be more complex concerning why it's essential that you need to use, say, ayahuasca and psilocybin and wachuma and an infusion made from morning glory seeds. I'm using those sacred plant medicines as a hypothetical example because of the key alkaloids that are in them, which are considered controlled substances. In those cases, it's DMT, mescaline, psilocybin, and lysergic acid amide. I'm going to pose a possible religious view that could be used as a defense for the use of these multiple sacred medicines. It mirrors enough of what many people more or less believe, though they might use different words. It's not necessarily what I believe, though it comes close to it in a number of ways. Yet, before doing that, I need to point out that this covers only part of what a group might be called to present. In this case, it would be their worldview about their need to use various sacred plant medicines. Yet, a RFRA defense would also need to establish other things, such as health and safety protocols, how you secure and track usage of your sacred medicines, the ethical beliefs and standards you have, what your ritual norms are, establishing that you have an ongoing congregation, all the things necessary for any group that wants to do a RFRA defense. So here goes a possible worldview defending the use of multiple medicines in a religious group, a specific religious group. Our religion understands humans to be inextricably enmeshed with the earth, which we refer to as our sacred living mother Gaia. The fabric of our being is made of the same fabric which constitutes the biota of Gaia and the mysterious universe that we discover ourselves in. This fabric of being is both spiritual and material. There's no difference between the two. The scientific narrative of contemporary physics reveals a structure of matter, energy, space-time, which we believe to be fundamentally mystical in its nature. And contemporary biology reveals us to be part of a web of life, which is interrelated and interdependent. No organism exists in and of itself independent from the rest of the flora, fauna, and geophysicality of Gaia. This includes ourselves. We're a sinuous network of tissue, liquids, minerals, and gases in an ongoing exchange with the rest of life and with spiritual dimensions beyond our normal domain of perceptions. Within this network of life, there are plants and fungi which allow us to understand, be unified with, and empowered by the mystical creative intelligence inherent in Gaia. These various plants and fungi speak to us. They reveal our nature, the nature of Gaia, the nature of creation. They do this because our nervous systems contain neurochemical keys, which are unlocked by these plants and fungi. The 5-HT2A receptor being a very significant site of a neurochemical key that our sacramental medicines interact with. It's necessary for us to use these different plants and fungi because their spirits teach us and transform us in different ways. They teach us in different ways because their different spirits manifest as different plant and fungi alkaloids, which open different neural pathways that catalyze different spiritual insights and mystical experiences, different spiritual, therapeutic, and somatic healings that we need to survive and flourish to find awakening and salvation. Our church has a variety of services which employ different plant sacraments. We sing different songs, prayers, and have different ritual norms when we invoke the spirits inherent in ayahuasca, wachuma, psilocybin, and morning glory seeds. But now wait a minute, let me stop this exposition because this is where the proverbial rubber meets the road. And then when I was working on an earlier draft of this talk, I thought I was doing a good enough job pointing to a direction a church using multiple sacred medicines might take. Yet when I read it to my wife, she thought it was a good lyrical description of why using plant medicines in general brings spiritual insight, but didn't see how it was a convincing legal argument for us for the use of multiple sacred medicines by a specific religion that would convince a judge or a regulator. Now, I know intuitively why it's true that using different sacred medicines may be necessary. I know experientially what the differences are. Yet it's quite a task to explain clearly in a way that would convince a judge or regulatory agency. I discovered to do so would take weeks, not hours of thought and research. And of course, I don't have the time to take such a deep dive today, though I still do believe it's possible to make this case with enough care and discernment. I'm engaged with my friend and colleague, Bob Otis Stanley of the Sacred Garden community, in debating and mapping out what that might look like. What I will say is that a church that did want to make this argument for using multiple sacred medicines in a court case or to a regulatory agency would need to explain in some detail what the differences are when you use each of these sacred medicines, what the different teachings and insights are of the different medicines, how the different medicines specifically inform the ethical dimensions of your religion and life in different ways. You might need to present evidence of how the different sacred medicines affect different neurotransmitters, present brain imaging studies which indicate those differences, and show how those translate into religious dimensions of your church's practices, and why it matters in a way that's so important to your religion that makes it essential that you use these different sacred plant medicines. This is a much bigger task than what the UDV, Santo Daime, or Native American Church needed to do. And I think most of us would agree we shouldn't have to do this. We should have a right to use these psychedelic plants, fungi, and agents that the earth has to offer us. Yet the reality is that RFRA is the only path of legality and defense that we have at the present time, until we change the Controlled Substance Act so it more reasonably accords with science, common sense, social justice, and cognitive liberty. So I hope I've pointed out the challenges inherent in making a case via RFRA for the use of multiple plant medicines by a religious group. Let me turn this off, excuse me. And I hope I've indicated some of the things you would need to consider if you were making such a case. And I acknowledge I tried to do this by beginning to present an argument concerning a hypothetical religious worldview that I more or less pulled the rug out from under. I think this further underscores why any group should be very circumspect in petitioning for a religious exemption at the present time, unless circumstances really called you to do so. If you are discreet and well organized, that may be your best protection at the moment, especially since the DEA and Department of Justice does not seem to be pursuing or prosecuting the religious use of sacred medicine at this time. So briefly, what about other groups that might want to seek an exemption for synthetic sacred medicines like LSD or MDMA? There are decades of examples of people that employ these medicines for spiritual insight and illumination. There are bona fide groups that feel that the use of these psychedelic sacramental medicines are fundamental to their religious practice. You can make the same basic case for them as you could with sacred plant medicines. Yet, I think where the challenge would arise is that the government would likely maintain that they have a compelling interest to prevent you from using these substances because they have a long history, because they have I'm going to say that paragraph again. I should have turned off the notifications on my computer. Yet where I think a challenge would arise is that the government would likely maintain that they have a compelling interest in preventing you from using substances like LSD and MDMA because they have a history of being recreational drugs of abuse, in their opinion, that are so dangerous you shouldn't be allowed to possess, distribute, and consume them. The scientific and sociological data do not indicate that they are particularly dangerous when used in a proper set and setting. So you'd have to amass and present evidence using expert witnesses to back that up. That would involve serious costs. The other major issue that you would face is that if you showed your use was not a danger to your church and the well-being of society, you would have to have a viable plan for procuring them. It's not likely that you would have the funds to set up your own lab that adheres to government standards for manufacturing Schedule I substances. You could conceivably contract to get them from a lab that has a Schedule I license, and to come up with a protocol to securely store them, as well as protocols to track your inventory. Yet things like that would also be likely very expensive. Growing and preparing plants and fungi is far simpler than synthesizing pharmaceutical LSD or MDMA. So again, with enough resources, there isn't necessarily any rational reason why you couldn't get a RFRA exemption. No rational reason, yet, as we know, government policy and judicial findings are not always what we consider rational. One last point on both multiple medicines and synthetics. It helps when a spiritual congregation can show its direct connection or association to a long-term spiritual tradition and community. Groups that use multiple medicines or synthetics are likely to have a more circuitous and indirect connection to such traditions. Yet, there is no clear legal basis that would preclude new religions from seeking their rights. However, that road is likely to be rougher and steeper. I'll end by saying that regardless of whether it makes sense to pursue a RFRA exemption at this time, the best thing you can do to protect and defend your church, your spiritual congregation, or whatever term you employ to describe your group, is to be well organized, to have protocols of health and safety, clear ethical standards, secure storage, inventory, and tracking of your medicine, a clear articulation of your lineage, beliefs, worldview, and practices, to be cognizant of issues around money and access, among other things. And the Chacrunas Council for the Protection of Sacred Plants is dedicated to helping people achieve this through our various initiatives. Thank you.
Thank you so much, Rob. And thank you, Jesse, Jack, as well. Really rich presentations, and in the chat stream, various members of our audience have been expressing appreciation for all of you. So thank you. And I want to give you a few minutes to respond to each other, if you have questions for each other. And in the meantime, to the audience, if you would add questions to the Ask a Question section, it's at the very bottom of your screen. Should be able to just click on it and add a question or vote for existing questions. So, Rob, Jesse, Jack, please, if you have questions for each other, I'll give a few minutes space for that and review the existing questions, okay?
Rob, do you have a name for the church?
Well, again, that was a hypothetical church. I'll say the two churches that I am part of, ayahuasca church and a Daime church, which are incorporated. We only use one medicine as part of our services, but that hypothetical church, no, I don't. I guess it would be the Church of the Sacred Holy Light of Gaia or something.
I like it.
Jack, I have a question for you. I guess one could say that at the present time, the Religious Freedom Restoration Act basically protects any well-defined and well-organized religious group, and that we could consider ourselves legal. It's only if the government decided to take some action against us that we would have to prove our bona fides.
Okay.
Your mic
And
is
your
off.
question is, my mic is off? It says on.
No, it's on now. Sorry.
Huh? Okay. But your question is essentially, RFRA only protecting, well-established churches? Is that what you're saying?
Well, no. Well, let me reframe it. I'm saying that basically, if I'm understanding your position and other people's position, and the position I would like to have is that the Religious Freedom Restoration Act at this point, one could say, basically already protects an existing religious group using, let's say, ayahuasca, or psilocybin. It's only if the government decides to take some action against them that that is called into question.
That's my interpretation, but also you have to understand that it's the Constitution, the First Amendment, that protects the right to use a sacrament. And RFRA the only thing RFRA does is it reestablishes a strict scrutiny. So RFRA itself is not protecting you. What's really protecting you is the First Amendment. And RFRA establishes a standard by which someone who's trying to prevent you or interfere with your practice, they have to meet certain standards. So you're talking about something like LSD. Okay, so there is a compelling interest, and that case has already been litigated. However, is the absolute restriction the least restrictive means? Probably not. So that's where I would argue. I would argue, yes, okay, we concede that there is a compelling interest, but that a complete ban is not the least restrictive means, and there are means by which we can meet all these concerns that the government have, which is diversion, addiction. There's no addiction for LSD, but diversion. Whatever harm that they believe that they can, prove, things like that. So that's where the argument comes in. So.
Right, and as I pointed out, and as we've discussed too, the big hurdle for substances like LSD would be actually procuring them, because they're pharmaceuticals that need to be manufactured as opposed to, growing, jagoubi and chacruna and mixing them together.
Right, but LSD is manufactured now. It's being used clinically, so you can procure it, and you can procure it from the same facilities that are producing it for clinical use and for other uses. I mean, no reason why you couldn't get a contract.
Right, and actually, I feel like.
Go ahead.
I'm sorry, I interrupted you. I didn't hear there's a lag in our. Yeah.
Okay.
Yeah, no, I may have even made an error saying it might be expensive to procure it, but if people in the underground can make it for a couple of dollars, you would think a lab, you might be able to have an agreement that wouldn't be as costly as I indicated.
I know who makes most of it for the labs. I could ask him how much it costs, but anyway. So, I mean, legally. But I agree with you. If we're going to go down this road, it's easier to go down this road with traditional medicines and establish precedents with those first. So ayahuasca was great, perfect, easy to. It's not a party drug. You're not going to go out and go to a rave and take ayahuasca. So there's a lot of the arguments that are taken away from the government. Psilocybin to me is the next logical one to push, to find an authentic church or spiritual organization that uses psilocybin mushrooms, because not same lineage, but a very long lineage, very safe use. I mean, it has all the same characters. And the really great thing about it is that most of them are non-Christian. Mm-hmm. Yeah, that part of the attraction to finding that the UDV and the Santo Daime was that because they were Christian churches, just like the American Indian Church. So it would be great to have a non-Christian use of an entheogen, that was that had a good outcome in a case. So.
Thank you. I wanted to open it up now to some audience questions. And there's two I want to start with. One, there was several requests to explain the SoulQuest case. And then also a more general question, how many groups have taken advantage of this petition process to date? So we'll start there and then keep going with the questions that the audience has posed.
So we have two ayahuasca groups, Ayahuasca Healings and SoulQuest, which submitted their petition about 2 years ago. Before the ayahuasca groups, there were a few cannabis churches that applied for petitions or petitioned for exemptions and were rejected. The one that has perhaps the best and most interesting precedent is called the Church of Reality. So I recommend going to bielabache.net/texts and click on legal texts, and you can read the Church of Reality's petition there.
And very briefly, the new filing that SoulQuest just did, basically a number of years ago, the DEA contacted SoulQuest, said that what they were doing was contravening the Controlled Substance Act, and invited them to make a petition under the Religious Freedom Restoration Act under their, the DEA's guidance process. They did do that. However, for the last 2 years, the DEA has not communicated with them at all, has not, had any contact with them, even though their lawyers keep reaching out to them. So they've gone to federal court to try to address that, and they're asking for a preliminary injunction and for the right to use ayahuasca as their religious sacrament. And they're also questioning the constitutionality and the viability of the DEA's guidance process. And this just happened 2 days ago, so we really haven't been able to absorb the filing yet and have a good handle on it yet.
Jack, would you like to add anything to those questions?
No, not necessarily. I mean, I just think it's a wrong avenue to take, because in their petition, they're basically stating that the the materials, the ayahuasca, falls under the CSA, which I just don't believe it does. So they go ahead and they basically waive a lot of arguments that they would normally have if they were being prosecuted for using ayahuasca. The other thing is that why bother going through this process, which is going to be rather expensive, and the weight goes so far over to the administrative side that I just can't see it being of any value to them. The other thing is that the judge that is going to be hearing this is a recent Trump appointee. So, I mean, there's a big difference between the legal theory that is in the law that anybody can read and feel that they can understand, and then actually going into court and being in front of a judge. We worked on the Daime case 10 years before we actually litigated it, because we set it up so that when something actually happened, we were completely ready for what was going on. If you're going to go to war, you better make sure that you're well provisioned, and it's like Sun Tzu. You got to understand your enemy. You got to understand yourself. You got to understand all these things. So my feeling is that I do a lot of environmental law. I never challenge, or very rarely challenge, administrative procedures, because they're generally a dead loser. So, anyway, that's all I have to say about it. But it'll be interesting to see what happens. You never know, and I'm continually surprised by what comes out of the court sometimes. Often disappointed, but continually surprised.
I'll just briefly add something too, that a unique characteristic of SoulQuest was that a number of years ago they were associated with the Oklavu Native American Church, which many of us consider to be an illegitimate organization, and not really a Native American church. And they tell their members and their branches that they are legal if they're under their umbrella. So SoulQuest thought they were legal because they were part of them and they were publicly promoting themselves. They then understood after a while that they weren't really. And however, they were already out there in the public eye. So, they have an unusual situation, but that underscores why it's good to be discreet and not to publicly promote yourself.
Issues that the DEA look at to determine genuine religious belief, which is just garbage. And if you go to court, the judge makes that determination, and he doesn't go through that list like that. We had wonderful testimony on the bench, and that was enough to convince a judge that these people had a genuine religious belief. His looking at Jonathan and Alexis and listening to them, asking them some questions, it was all of 15 minutes. It wasn't some long process. So, of course, their established religion, they had the other merits that went with that. But and then who's to say when DEA decides to change their list, or they just decide that they're going to add something this, or you're going to add that, or they want to talk to the individual members. I mean, it's so often arbitrary and capricious that you're just better off taking your chances and letting them sue you, which is not going to probably not going to happen. So unless you're really deserve it in a sense of you're doing something outrageous, somebody has died, somebody has complained or something like that. And that goes back to what Rob is saying, is that you want to make sure you're really clean and well organized and you have your shit together.
Thank you. I want to propose to you all a question from the audience about the FDA, actually. Or several audience members interested in this question. And the question is, and you all can read it in the Ask the Question box, is it possible or advisable for a company, nonprofit, or for-profit to appeal to the FDA for a religious sacrament exemption for conducting clinical trials on ayahuasca? Possible goal of this being to allow for the use of religious traditions, shamans, ceremonies, etc., in the clinical trials themselves. What do you all think about that?
Well, the simple answer is it's not a question of a religious exemption. The FDA is a different authority. It's the Federal Drug Authority. If you're going to do clinical trials, you do have to go through the FDA. And at that point, it would have nothing to do with religious freedom. So if you're going to study ayahuasca that way, it's just a whole different regulatory system. I don't know if anybody else wants to say anything else. That's the simple answer.
Would anyone else like to comment on that before we move on to another question?
I don't have anything to add to that.
Okay.
So there are groups studying DMT and MAOIs, human subjects, clinical trials. Maybe they're not using shamans and they're not doing it in a religious context. Maybe they are. I would dare say that they probably are doing it in a more clinical environment, in a more clinical fashion, and trying to remove as much of the religiosity from it as possible. Whether that's right or good, I don't know.
You got to go to the FDA. It's not an issue for the DEA. So,
So I just want to share that a couple of things from the chat box. That there are a couple of comments. One that one audience member suggests that conservative judges are perhaps the perfect ones to hear a religious freedom case. So I know this was originally meant to be a conversation, and so I wanted to try and make this a little more interactive. And then there's also someone who suggests that this FDA DEA relationship is a little bit complicated, and that often one will use the other as an excuse to block or ignore a decision, and that MAPS has been involved in what this audience member describes as an ask mommy, ask daddy kind of game. So I wanted to put that out there in case any of our panelists want to take that up. And then I'll move on to another question that got quite a few votes. Is it possible, and has there been any consideration of specifically challenging the DEA's authority to determine the validity of religious practices? Where do they derive this authority? Related, how do we know who exactly at the DEA is the one determining what is a valid religion and what their credentials are? Finally, how were these religious criteria determined? So pretty big questions here.
Actually, the SoulQuest case, I haven't looked into it deep enough, but they seem to be raising that. Jack, you might have read it more clearly than I have. Maybe you could speak more to that.
It's just a waste of time to challenge the DEA. Okay, the judges all work for the government. I mean, okay, so that's just so you know. And they defer to agencies. They don't want to see chaos. They don't want to see every agency decision challenged. They want order. They want law and order. Okay, so it's a waste of time to challenge the DEA. If you have a genuine religious practice and you have a good organization, you really should, you have nothing to fear. You just go along and do your business. You're in a much better position waiting, even if it ever happened, to be sued, assuming again you're in a RFRA state, or the federal government does something, because the government then has the burden of proof. You're not trying to prove anything, and these other administrative things are going to be expensive, and they're going to just end up with basically the judges supporting what the regulatory agency does, because judges, although they're in a good position to determine the law, don't like to take on interpreting regulations in and of themselves or making law, which is what they would do if they strike regulations or modify them and so forth. But I'm just saying it's a can of worms. It's a lot of work. To talk to anybody that does administrative law, you kind of realize that. And then going to the conservative judge. Our judge was a judge from Oklahoma, put on the bench by Ronald Reagan. Conservative as can be, but this is where the rubber meets the road. We picked I was a second chair in the trial. We picked a trial attorney who was good friends with the judge. Okay, that's what we did. So, I mean, there's a lot of strategies that have to go into these cases that have nothing to do with being on the merits of your case. So, and yes, some conservative judges are great and some are not. And I don't really know who's who, but who that judge is does make a difference. And you're more likely to have a conservative judge want to uphold regulations than want to upend them. That's the pattern. So.
Although, just kind of related to that point, one of the reasons some of us are interested to see if it might be possible to negotiate with the DEA and Department of Justice is that a lot of people don't like the fact that they feel that they might have prosecution hanging over their head sometime in the future and that they have to have a lot of funds in reserve to go to court. So, that's why there's still interest in looking at what other angles are there here, either to question to see if there could be some better process, put in place. But, and it would have to be done really well and depends on who there is to talk to at the Department of Justice and all that. But yeah.
DEA. So I don't disagree with you. We wouldn't go through the process or request an exemption, but we spent 2 years meeting with the DA trying to work out some sort of compromise to avoid the problems that happen later on. And I totally agree with you. I think it's a very sound means to avoid problems in the future, to get an agreement with everybody, including the government, on how to deal with this. So, sort of think about medical marijuana and then having that convert over to legalization. I mean, it's a very long process, but it has been working. And part of that was, working with law enforcement, getting recommendation from them, getting them to be on board with it and so forth. So I totally agree with that process.
So there is a question asking if the DEA or state authorities have a history of targeting any groups that have applied for an exemption. And this speaks, to this theme of seeking some kind of cooperation or negotiation with the DEA. But is there a history of targeting groups that have applied for an exemption? Jax?
Not that we know of. There may be some groups that applied for exemptions we don't know about it. As I mentioned earlier, the DEA, Department of Justice, seems to be not targeting sacred medicine using groups at all. There still have been some incidents. They tend to be at the border or through the mail. A couple of those incidents happened, a year or two ago. But, for the most part, we don't really know of them going after anyone at this point.
And if you think about it based on your constitutional rights, the inverse should actually be true. Because of the Fifth Amendment right against self-incrimination, if the DEA were to actively go after people who've tried to apply for exemptions, then they would be pretty flagrantly violating the constitutional rights that we all have as US citizens.
So, if does anyone else want to contribute to that question before we move on? I just want to make sure. I know there's a bit of a lag.
I'm agreeing no, that they haven't. So, but we did have, during the Daime case, we had a lot of conversations with DEA, and they know a lot of what's going on with groups and what's going on with everybody. And they basically told us that they just don't have the resources that they're more interested in heroin, cocaine, methamphetamine, these really serious issues than to go after every small group that's doing infusions. And if they have a concern, they generally just turn it over to local law enforcement, which is, a reason why you should determine whether your state has a RFRA statute, because you've got really very little protection if local law enforcement does decide to get involved. I mean, protection with regard to RFRA.
Okay. The next question has to do with the designation of sacred plants and practices and putting them into a religious framework. So there's a comment in the chat: putting the practices and the use of sacred plants within a religion framework and applying religion criteria is in itself a submission to the general consensus on plant medicine. And if I may add to that, it's a question I also have for you. Does it transform these practices in some kind of way that may not be so positive to try and fit them into the frameworks of RFRA or of the category of religion?
Well, I think a lot of us, almost all the groups we're involved with can be described in religious in some way. Remember, religion, that includes all kinds of spirituality, all kinds of shamanism. I mean, it's a broad term. It doesn't mean an institution, a Judeo-Christian institution. It's very broad. So, and we're not suggesting that people take whatever practice or usages they have and try to fit them into a frame, because that wouldn't be authentic. I guess when we talk about delineating what your worldview is, what your beliefs are, like clarifying those are something that would help protect you if you were called on to defend or explain yourself. But it's also, if you're seriously involved with any kind of religious or spiritual practice, shamanic practice, it's good to do that anyway. It helps clarify who you are to yourself and your group, anyway. But other people might have other views on that.
It drives towards the meaning of this word religion, right? Religion comes from the root religio, which is to bind. Religion is something that binds us, which creates a kind of oxymoronic moment for the practitioner of psychedelic plant-based religion, because psychedelics are liberating. So how do you have a religion that is binding you to something that is liberating you by its very nature? And it reminds me of a quote from Alan Watts. And the quote goes, "Once you get the message, hang up the phone." And the rest of the quote, which I really like, says, "For psychedelic drugs are simply instruments like microscopes, telescopes, and telephones. The biologist does not sit with eye permanently glued to the microscope. He goes away and works on what he has seen."
Any further comments on that question? No. Okay. All right. So we have a question about the importation of medicine, particularly ayahuasca, into mainland United States. Does having filed or prepared a DEA exemption help mitigate the risks? And there's a similar question. I'll combine these. Are ayahuasca churches importing the plants or growing their own? If someone was to start a psilocybin-based church and they were growing their own mushrooms, would that add another layer of manufacturing to the risk?
Applying for an exemption wouldn't, in and of itself, protect you. And technically, I guess if you're growing mushrooms, and you're drying them, you could be considered to be, manufacturing a controlled substance. But I don't know I know of no cases of the government going after groups like that. I mean, people, when they go after mushrooms, tends to be many pounds of them, but the other people have perspectives on that. But again, just applying for an exemption wouldn't technically protect you. It might, might be a...
You're telling them you're importing it. It's like, why would you do that? I think it's everybody that's applied for an exemption, have they gotten one? No. So it's a waste of time. Why would you bother? But the importation and manufacturing and production is a real concern. And it does give DEA a foothold with regard to their own regulations, much more than just the use in the religious use. So, again, I think at that point, what DEA's been doing, if they catch materials, they just send them back. So unless they're like the Daime, we import stuff all the time, not a problem. But we do keep records, and we do provide them to the DEA. We don't have an objection to doing that. So, but it is a can of worms, that whole the manufacturing, and it does increase your chances of liability. And if some of this gets diverted, there's a real serious problem there. So. Applying it.
Jack, I think you were starting to say something, but then are now muted. I want to check in and make sure. Was there something you wanted to share?
Other than the only thing I'm saying is that applying to DA is not going to help you with regard to manufacturing or importation. So the best thing you can do is just keep really clean records and have that X comes in and then it goes to this place, and then every bit of it is accounted for and it's all been used for religious purposes. That's a much better protection than trying to apply for an exemption.
Just picking up that thread, because I agree that it is a waste of time to apply for an exemption. But I want to highlight the fact that it can be useful to go through the exercise, like a sand mandala. You do all of the motions of producing the articulation for your group, and that in itself is a useful exercise. And then you wipe the mandala away instead of submitting it to the DEA.
No, I totally agree, because you have to be prepared to go into court. The other thing about what Rob, just a point about Rob's concern about costs, it's not very expensive pursuing some of these cases. I mean, first of all, if you prevail, you get your attorney's fees and costs back, which we did, and so did the UDV. A lot of attorneys will do this on a contingency basis because they get their attorney's fees. And a lot of the experts do it on a reduced fee basis because a lot of them are just they're very excited about this area and are willing to provide their work at a very low amount, hoping to get paid their full amount, if you're prevailing. So you can get by in these cases on a fairly slim budget. I mean, but you do have to, you do have to be prepared, and you do have to have, your ducks in a line lined up. So, but I don't think there's going to be very many prosecutions unless something goes wrong. Somebody dies, somebody complains, somebody's, you're giving it to children, you're selling it on the street, something like that. But if you're careful and involved in your religious practice, the DEA just doesn't want to bother with a case like that. It doesn't look good to a judge, and it doesn't look good to a jury. So.
Yeah, and related to those comments too, I'll just say again that the Chacrunas Council for the Protection of Sacred Plants, that all three of us and many of us and some of the other talks are involved with, we are creating initiatives, some of them discreet and private, and others public, to try to help organize the community around these questions, so that we can, have consensus about standards and stuff, and that if issues do come up, we can support each other and know who each other are, and move together as a singular force as much as possible.
And for people who are interested in networking with lawyers who are interested in these issues, you can go to psychedelicbar.org and sign up for the Psychedelic Bar Association mailing list.
Jesse, if you would write that in the chat, I think that would be very helpful. And the last question that I think we'll have time for, unfortunately, is exemption seems to apply mostly towards group plant use. Are there, if any, religious freedom protections for individual sacred plant uses?
Technically, yeah, RFRA doesn't make that distinction. I don't know of any recent individual cases of someone doing that. I don't know why someone would, unless they got into, trouble, they got arrested. But, technically, an individual could petition for their own use.
Just so you know, under the First Amendment, there are cases where individuals have won cases for their religious rights as individuals not associated with, a standard church or something like that. So there is a history for that. But cases are all fact-based. So, it all depends on what the facts are.
I want to give all of you 45 seconds to a minute to summarize your positions coming out of this conversation. And I think we'll end with that. Jack, would you like to go first?
I think my position has been well made. I think it's a waste of time to apply for an exemption, and you're much better off spending the time and energy and money bringing your organization up to a stage where, if any actions brought, you can easily defend them.
Thank you. Jesse.
My position is in favor of the emergence of what I consider to be a new religion. And it's a religion that I very much consider myself to be a part of. And it's a religion that, since that fateful day that I had a celebrity moment and encountered Pia Lavache, I've had the privilege of serving as an author and as a speaker, and now as a lawyer as well. And I look forward to continuing to serve this emergent movement, whether it's in creation of exercises in futility, like a sand mandala, or in concentrated and concerted action. However it is, it's really my pleasure to be a servant of this collective vision and helping it come to life.
Jesse, thank you. And Rob.
Echoing what Jack and Jesse had said, basically it's to engage in best practices of health and safety and organizing yourselves and connecting with other people in the community that are concerned about these issues around legality, around justice, around access, And the more we can all come together on that, both as individual groups and as a collective, then I think we'll be able to meet the challenges that might arise in the future. And so keep in contact with us at Chacruna and look at all the good things that are happening during this conference, and the more alliances we can make, then the stronger we'll all be.
Okay, Rob, Jack, Jesse, thank you all so much. There's a lot of, in the chat stream, messages of appreciation for these conversations. So thank you all. Thank you to the audience for participating today. Take care.